You've already agreed to 10 years, no negotiations, no whatever. This is it. You violate, you're getting the 10 years that you agreed to way back when. Do you understand? Now, the misdemeanor is something that, remind me, why do I have that on?
He was supposed to have pled to his misdemeanor several resets
Right.
each time prior to coming down here, because our plan is to have him, we had talked about
To extend probation and ISF.
But now it is for safety if the court considers based on this update PSI, but obviously we can't do that until he pleads to the misdemeanor.
Well, I can do that today and he can go into custody and y'all can go take care of it.
That's what I was just going to.
Because he'll sit in custody until he goes and
Correct.
takes care of that other case, because he won't
That's
go. All right. So in cause number 16-24485, first year James Loftton. Mr. Loftton was previously in court, and that is a motion to revoke probation. On probation for the third-degree felony of assault, family violence. It was a 5-year deferred at one point, and then in February of 2020, that probation was revoked and given a 10-year term that was probated for 5 years, so went to a straight probation, placed on high medium caseload and zero tolerance. I've received the updated pre-sentence report also. Has everyone had an opportunity to review that report?
Yes, ma'am.
I have your-
Any additions or corrections to that?
No, ma'am, the only thing I would say is since PSI is that we have, this last week, we have gone and taken a drug test of Beaumont Occupational, my client has, is that, and I have those drug test results at the court within.
That's not going to change
Okay.
what I do based on the nature of that examination and the substance abuse evaluation. I'm going to follow those. I appreciate that he stayed clean for some amount of time.
Yes, ma'am.
But if I'm going to follow after what I just said with regard to the
Yes, ma'am.
nature of where we've gone on this, he looks like there's a new misdemeanor, driving while intoxicated, second, and that was from December of 2023. We're just finally getting here, so I'm going to do what's necessary, I think, if I'm going to leave him on probation to keep everybody safe.
Like I said earlier, Mr. Barrington and I had previously discussed after we both reviewed the PSI that safety may very well be.
Yeah. That's what it appears from that evaluation. And so I rely on them and their evaluation to say what's best and do it. And then they're talking about the not just the regular SAFP, but special needs SAFP, so that it covers everything from mental health to drug treatment to everything else that would be necessary, hopefully, for Mr. Loftton to finally be able to complete this probation. In addition, I will have to, and not just have to, but I will need to extend and plan on extending that probation period as well, because it's up either already or this year, and it's only pending because of the motion. Is that right?
Yes.
Okay. All right. So anything else with regard to that updated report or with me going forward with sentencing?
No, ma'am, other than the fact that he is working, I have his employer here, if you'd like to hear from them. We would ask that, the recommendation initially was ISF, and we would ask the court to consider ISF and sentencing instead, because he has been working with stable employment with his employer for more than 1.5 years now, has had stable housing as far as that goes. And so we feel like that him going to safety would cause financially devastating for him. And so we would ask that he be allowed to go to ISF and then have more strict monitoring on weekly reporting and weekly drug tests with zero reporting.
Ms. Maltino?
I defer to the court's discretion here, but just my review of the PSI. I think safety is probably helping.
And so with regard to Ms. Jefferson, you initially also agreed that ISF with being on the high-risk caseload after would be appropriate. Is that what are your thoughts?
Yes, that was my initial recommendation. But I also included that I don't know much about his case because he had absconded for, I believe, over 2 years.
Yeah. And it looks like there was tested positive for methamphetamine August 14th, last month, denied using it, but stated he had used a month ago, but tested positive for it. So I'm trying to see what specifically, why special needs?
I don't believe there was any sort of psychiatric.
I didn't see that either, so I'm not real sure.
That was kind of what, the only question I had about it was.
I don't think we
special
need-
needs is generally
It is, if there's
more
some
of a
type,
psychological type situation.
we don't have that, so
We
it's just
don't.
regular. Okay, so here's what I'm going to do. Mr. Lofton, I am going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I am going to continue you on probation. I'm going to extend your probation period for 3 years. I'm going to order as a condition of your probation that you enter and successfully complete the SAFP program, not the special needs, but the regular SAFP program. And that you'll be on the high medium caseload when you get out. You'll be required to do aftercare. I don't know how to stress strongly enough that this is your last chance. You will not, if you are back in here, I'm going to look at this paper and I'm going to wonder what I did and why. So you will be required to have a drug patch on at all times when you get out. If there's one positive, you're back in here and looking at that 10-year term. Yes.
Judge, the only question I have is, I think he was put on probation in 2016, wasn't he? Is that, can we extend for 3 years?
Well, he was put on a deferred in 2016,
Okay.
and then he was revoked and given a straight probation in
Okay.
2020. So actually, I could extend him for 5 more years
Got it.
instead of just 3.
Got it. Fair enough, John. Thank you.
I'm going to hand you the trial court certification. I need y'all's signature on that, showing that this was an agreement that I followed. And so you've waived your right to appeal. You'll go into custody. Obviously, Mr. Barrington will get it set up as quickly as possible for you to go take care of that other case down the hall in misdemeanor court, because until that's taken care of, you will not be able to go to safety. So y'all need to get that taken care of as quickly as you can.
Yes, sir. Yes, sir.
Thank you for being here. Thank y'all.
May we step over here, Your Honor?
Y'all just sign it real quick right here and they'll take them back. Thanks, Mr. Barrington.
Where's the sign on this? We're just right here where it says defendant.
Mm-hmm. Here, I'll give you the, hold on a sec. Here, a copy for you.
Thank you.
Thank you, sir.
Yes, ma'am. Thank you.
Mr. Burbank, you've got Renisha Chase on.
Yeah, my paperwork,
I have one of them.
yeah, the other one's an MPRP. I'm pretty good.
He has 2 cases.
Mm-hmm.
One of them that he's saying is an NTRP, they didn't do paperwork on, but the other one's in the case.
Just our intention, if the court would allow, is to have her enter the plea, do a PSI, to kind of see where she is now. This was a case we brought over from CDC, and then decide what is best on the motion. Either to dismiss
The
it or
burglary of a
continue.
hab is the MTRP.
Yes, ma'am.
Okay, for some reason that's it. Before we go any further, I've got a note to remind myself, I have a seat in the jury box. I'm going to get a drug test first. Hang on to it because it'll get mixed up with my other stuff. Please and thank you. Thank you. You don't want it to get lost in the abyss that I have going on up here. Ms. Cawthon, you have Zachary Turner. Good morning.
Good morning, Your Honor.
Morning, Mr. Coleman. Good morning, sir. You're Zachary Turner. And this is 24 DCCR 2197. Mr. Turner's charged with fraudulent use or possession of identifying information. And what is the announcement?
Your Honor, we're needing a reset. I've talked to the prosecutor and we're needing some more evidence.
There appears to be maybe some videos that did not make it to our file,
Okay,
and thereby not turned it to the defense counsel. And I'd like some time to run it.
sure. All right, so I'll just do a normal reset. Mr. Turner, make sure you stay in touch with Ms. Coughlin. Once she gets that information from Mr. Coleman, you guys can meet and go over it, and then we'll see if we can get an announcement at the next court date. All right, thank you. You're free to go. Thanks, Ms.
Thank you, Your
Coughlin.
Honor.
Let's see, is Mr. Cole here? Mr. Leish? On Carly Davis? Carly Davis Hoosier. Is there, Mr. Coleman, witnesses on this or just argument? or-
And I got the message about the re-indictment. I'll just take care of that.
It's a mess.
It was.
I tried.
It was pretty convoluted.
All right, you're Carly Davis and Carly Hoosier. And this is 24 DCCR 1385 and 25 DCCR 1237. And so their state has, we were going to be here on reviewing bond conditions, correct? And then the state has filed a motion to increase the bond.
It's just,
And is that in both of the cases or just that one?
in both cases, Judge.
Let me pull this up. I know I took a look at it last week, but
This one's Judge.
and so we've got both of these cases are driving while intoxicated, third or more. The first offense date is from May 6th of 2023. The second from February 10th of 2025. Give me just a second here. Well, it's working. It's just working slow. So I've got some history with regard to prescriptions. Some of it's obviously very hard to read, but it looks like prescriptions for alprazolam and something called D-amphetamine. Okay. Can't tell the date. One of them specifically says no refills. I can't read the dates on these.
We can get better photos, Judge. She had had that prescription for,
All right, shows it expires October 31st for the,
Judge, I had a number of questions about those photos myself. I mean, I'm not necessarily, well, I guess I am questioning the validity. This doctor that allegedly prescribed it, this Rajan Desai, there's either an Austin address or a Millburn, Texas address for this doctor. When I looked him up through the Texas Medical Board, and I'm just a little curious about.
so where do you go to the doctor? Where's this doctor from?
From Beaumont, and I do a telemed every month except every 3 months. I go to his office. I don't report it today.
Today?
Yes, ma'am.
Where specifically?
Telemed today.
Oh,
Yes.
well, here's what I think I'm going to do based on the nature of what these medications are and the history. Well, are you driving? Okay, there, I don't know if I already did, but a condition of your bond is going to be, as of today, that you are not allowed to drive any vehicle ever, period. Okay, so if you're caught driving, obviously you'll be right back in jail without, probably without a bond. Mr. Coleman, other than a no driving, is there any other?
No, Judge, I just would like to reiterate, and we put it in our motion. It sounds like, of course, we read the motion, but she's got 4 previous DWIs, Judge. And in addition, she picked up this latest DWI while out on bond for a DWI.
Right.
And that along with the positive drug test, I think the public safety, the community safety demands some additional assurances.
And Judge, our argument would be that the DWI itself is for the medications. She's been on these medications for.
Well, it doesn't matter if you're on medication and you're
Right.
taking too much medication, then that's a problem.
Sure.
So you can be on these medications and not be.
Also, the failure of the drug test was for these medications.
Right, I understand that. My biggest concern is the fact that if the medications are not being taken properly or too much of the medications, then that's a larger concern with the safety. And I completely understand and agree with Mr. Coleman on that. How'd you get here today? Here's what I want you to do, what I'm going to order you to do. I'm going to order that at your appointment, I'm requiring you to find out and with your doctor, get a prescription for something that is non-narcotic. So something that is not going to cause these issues if in fact our concern is that you are misusing or overusing these medications, then there's other medications that you can take. You need to talk to him today. I want you on your way to be off of both of these medications and on something that would not lead to the issues that you're having. Does that make sense? You need to get that information from him, find out what he can prescribe. I want those to Ms. DeLage and I want her to get those to me. That is a condition of your bond at this point. If you don't do that today at that appointment and get that information to her, then I'm going to, what I'll do today is not rule on Mr. Coleman's motion. So that motion to raise your bond is still out there. And if you don't get this information and you don't get this done today, then your bond will likely be raised and you'll be in jail. Do you understand? All right.
My only question is, the medication to get off of it abruptly can cause.
I understand that. I'm not saying you have to get off of it abruptly. I'm saying I want the plan and how you're going to do it, what it's going to be reduced to, what it's going to take its place, whatever it is. I want that. You need to tell him that you have been ordered to get off the medications, but obviously that needs to be done in a medical way, but I want whatever that plan is and how you're going to do that. And I want that to Ms. DeLay so she can get it to me tomorrow. Okay. All right. I'll free to go.
Thank you, Your Honor.
Okay. Thank you. See,
Diamond James.
Mr. Floyd, is Mr. Floyd here? Mr. Choate, good morning. Good morning, Mr. Choate. This is Richard Afong Wade, 23-41318. Mr. Hoffbauer, good morning. Good morning. You're Richard Afong Wade. And Mr. Afong Wade's case is set for trial to begin with jury selection next Monday. Again, what is everyone's announcement?
Unfortunately, we had to file a motion for continuance. Mr. Floyd had to have a partial knee replacement last Wednesday. He's under doctor's orders not to sit or stand for long periods of time. And so we had to file a motion for continuance. So I guess I'm honestly does not make sense.
I got the message, I don't have an issue. I mean, I can't remember.
Sure. Is there a timeline on that?
So in the next, I think he's got to follow up in 3 weeks, and then they'll reassess what he's allowed to do, right? Because like right now, he's still like at home.
Sure.
So,
Okay, so I'm going to reset the case to the next trial docket to give them plenty of time. Obviously, you guys know this was going to be the number one, probably. It's really going to be up there next time. So as far as age goes, I'm going to set it, and if I need to protect everybody, I can do protection orders from other courts if you need that as well, because it'll be time to get it way past time next time.
yes, Judge.
Tell him I hope he gets better, and we'll see y'all at the next trial docket.
Thank you, Judge.
You're free to go.
Appreciate it.
Thank you, Judge.
Mr. Franklin, you've got Ray No,
Yes, sir.
2 cases. Morning.
Good morning, Your Honor.
Good morning, sir. You're Ray No.
Yes, ma'am.
And in cause number 25 DCCR 0386 and 0387, Mr. No is charged with intoxication manslaughter and the other driving while intoxicated with a child under 15. And what is the announcement?
We are ready to proceed to trial by jury, Your Honor.
Okay, have y'all done a rejection? So what I'll hold it while y'all do. On the tablet, there's a plea bargain rejection.
Okay.
If y'all will get that signed with whatever has been offered that you're rejecting, and then I'll go over consequences, options, all of that, and then we'll get it on the trial docket.
Understood, Your Honor.
Okay.
Get that file.
Yes, sir, thank you. I'll hold it while y'all get that taken care of. Is Dontrell Scott here? Mr. Scott, Mr. Johnson called earlier. He is not going to be able to be here. He's ill. I'm going to reset your case. You're free to go. Just stay in touch with Mr. Johnson in his office, and they'll let you know when you need to be back. Thank you, sir. Mr. Kelly?
Yes.
You've got Adam Moe.
He's present. Good morning.
Good morning. Good morning. You're Adam Moe? Okay, so we're here because Mr. Moe is on probation
Yes.
I did a different type thing where Mr. Moe went and did some time on some of his cases in prison, got out and is now on probation. Apparently, there are some potential issues with regard to where he's living that weren't issues with parole, but are issues with probation. Is that correct?
It sounds like they may be issues with probation.
Okay.
That's kind of why our original emergency motion had a strange title, because we didn't know what else to call this.
Sure.
Other than in an effort to make sure that he is doing everything correctly. I think our mission on that was, let's get in front of the court and make sure this is being done correctly.
So what's the issue potentially?
Adam's parents, Jody and Chris Moe, who the court may remember, and they're present again today. While Adam was incarcerated, went to a number of links with the folks from parole to make sure that any home that Adam was going to live in upon his release and beginning the out of prison portion of probation and parole, he's on parole too.
Correct.
That their home where he was going to live was in compliance.
Right. Parole's approved it.
Parole has approved it.
So where are we?
If the court doesn't mind, I can go and say the address.
No, I don't need that. I just need to know what the issue is with
The
probation.
issue is we are at 574 feet from a church that has a playground attached to it. And I don't want to speak for probation at all, but condition, I think it's 33. It isn't vague, but it's neither inclusive nor exhaustive. So I don't know exactly what the conversation was that probation had with Adam the day that he reported immediately upon his release from prison a couple weeks ago. And I don't believe that the conversation was, hey, you can't live there. It was, this is kind of an issue. So our position is a lot of effort was made.
So what's the issue?
Excuse me. So his condition number 33 says that he's not to be within 1,000 feet of places where children call or gather. So
Right.
it's not limited to that list. And so I believe it's the 574 feet from the church with the playground attached is the issue.
Okay. I'm looking at the order now. Mr. Hoffpower, any strong feelings one way or the other?
Judge, we'll leave it to discussion with court. I understand what probation is worried about.
Sure.
Set them up to fail. I do understand that's unique with parole and probation, two different entities, but
Well, and the
I don't want to
offenses
violate.
were possession of child pornography.
correct.
There weren't any allegations of
There were 10,
assaults or anything like that.
Correct.
there were
Okay.
just 10 charges of possession. And 5, we put 5 down penitentiary and 5 with probation.
Right. Is there a GPS at this point?
No,
He hasn't had his initial, actually, the assignment is tomorrow. He just did intake and correct me if I'm
Sure.
wrong. He just did-
No, and I appreciate being proactive, and that is good. We don't want to be in here the first month because there's a violation, which technically that would be a violation. There's no doubt that it's not vague. That would for sure be a
No,
violation.
in my reading too, on the geography of this thing, Judge, is that if Adam were to make, I'm going to call it a left turn if I've got the map correct in my head. If he were even to turn incorrectly down the main street where this house is, that would be a parole violation. So our position is that parole's assessment here, and I know the numbers are what they are, but that it covers both issues. So it's not like there's some kind of leeway to go even closer to that facility. He isn't going that way. He cannot, or he's in violation of what's been set up for.
Judge, Ms. Roach says if he lived there, he'd be sentenced to his grandfather.
He's not, though. They specifically moved to
Okay,
thank you, though.
yes.
Ms. Roach is watching to make sure, because if you were living somewhere already, there's kind of a grandfathered in, but they specifically moved to try to make it better. And okay. Well, here's what I'll do. I will allow a modification of number 33. That I want it to somehow, some type of addendum or attachment that's very specific, because this isn't going to be a exception for all, only for this specific. So I will need probably the address of that church so that in the orders, it says that you can be within 574 feet of that specific place. 33 stays the same for everywhere else. So it can be 33 can read like it does, and then you can add with the exception of that one place. Also, at least for, I would say, 6 months or so, or depending on how probation feels once he gets going, and if he's following all the rules and treatment and things like that with the LSOTP and all of that stuff, then I want a GPS monitoring device on at least for a minimum of 6 months to make sure that the rules are being followed, that he's going the right way, and there's not any issues. And that way, once we're all more comfortable with how things are going now that he's out of prison, then I'm okay with getting rid of that once you're okay with that, if he's following through with treatment and everything like that. Make sense? Okay.
Just one question. I think there's not school.
It's not the school issue, it's just the church.
The church. Yeah, the church with the, so I want that, that's the only exception, and the exception is the 574. So like you said, turn the other way, don't get any closer than what you're saying. That way there won't be an issue with it being any closer than what you're saying at any times that it would show up on that GPS. Make sense? Okay?
Yes.
All right, thanks. Y'all are free to go. No, ma'am. Mr. Burbank, Renisha Chason. Ms. Chason tested negative for everything, so that's good. Thank you. Yes, thank you. I need your signature though. All right, ma'am, you're Renisha Chason. And will she waive the formal reading of the indictment?
Well, Your Honor.
And again, we're just going to get a plea on the new indictment, reset the MTRP case, and come back and see where we are with the pre-sentence report. Is that correct? Goes with that also.
Judge, just to refresh the court's recollection, the co-defendant in this case, who is the, in my opinion, much more culpable defendant, has already pled the TDC time.
Okay, thank you. Ms. Chason, in cause number 24, DCCR 2351, you're charged with the second-degree felony offense of injury to a child, and that's from July 19th of 2024. And how do you plead to that charge? I'm sorry? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand? And it looks like the agreement that you've made is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, states 1.
It's admitted. Is there any evidence that Ms. Chason is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so that the probation department can do a pre-sentence report. And if that can include an update also on the probation case where the motion's filed, so I can have all that information as well. And then we will come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today. And she's sitting at that desk right over there. All right, we'll see y'all back at sentencing.
Would the court consider allowing her to remove the drug patch? It's costing some money that she doesn't have.
Not until sentencing. We're going to keep it on until sentencing. Make sure you keep it on and keep it updated. And then if everything goes well,
When do I come?
it's about 5 or 6 weeks. Okay?
Maybe excuse me.
Yes, thank you. Mr. Franklin, on Mr. No.
Yes, Your Honor.
All right, again, sir, you are Ray No.
Yes, ma'am.
And Mr. No, in cause number, hold on, let me get it pulled up. Cause number 25, DCCR 0386, you're charged with a second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 0387, you're charged with the state jail felony offense of driving while intoxicated with a child under 15. in the same offense date of December 11th of 2024. And in that case, if you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
I have here on the tablet in each of your cases plea bargain rejections that you've signed with your attorney that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. In the intoxication manslaughter case, that offers for 18 years in prison. And then in the
I think I'm watching wrong.
Should be two.
It should be.
2 years state jail?
Yeah.
No, okay,
Yeah.
all right. Okay, if I make that modification?
absolutely,
Thank you.
Judge.
So in the other, well,
And if you can't read my writing, I'm
nope,
happy
that's
to-
okay. I'm obviously don't know how to erase because now I'm just making marks all over this document. I feel like I know how.
That should do it.
Okay, so. Good grief. It is a Monday. All right, so in that state jail felony case, the offer is for 2 years. In the state jail prison, it would run concurrently with the other case. You have every right to reject these offers and have both of your cases set for trial. I just want to understand, make sure you understand what the possible consequences are if you go to trial, what your options are. And do you understand all of that?
Yes, ma'am, I understand.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
Okay, we'll get that done. And Mr. Coleman, is there any reason to believe that these offers would change? Is there any evidence that you're waiting on or anything like that?
No,
So I do want to make sure you understand that after today, Mr. No, I won't accept this plea agreement. If you change your mind and want to enter a plea of guilty, that would be to something different or open to the court unless there's new evidence that your attorney or the district attorney gets or finds out about between now and then. Make sense?
yes, ma'am.
Okay, we'll see y'all at trial. We'll get it placed on the trial docket.
Thank you, Your Honor.
Thank you.
Your Honor, may be excused.
Yes, sir. Thank you. Yeah. See, Mr. Valles?
Yes, Your Honor.
Good morning, sir. On Crystal Calvillo,
Yes, Your Honor.
Calvillo, I'm sure I'm saying that wrong. Good morning, sir. Good morning, ma'am. You're Crystal Calvillo?
Yes, ma'am.
And Ms. Calvillo was previously in court and cause number 24 DCCR 2456 entered a plea of guilty to the state jail felony offense of theft of property. I've received that pre-sentence report. Any additions or corrections to that report?
No, Your Honor.
Up to state.
All right, ma'am, I'm going to find that you entered your plea of guilty previously freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years.
Yes.
You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the felony conviction on your record. And at the end of that probation period, if you successfully complete it, the case is actually dismissed and you will never have that felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and then you could be sentenced anywhere in the range of punishment, which is up to 2 years at a state jail prison. Do you understand? And there's no restitution, correct? Okay. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation, she's going to call you up to her desk when she's ready to go over all of your paperwork.
Thank you.
Good luck to you, ma'am. Thank you, sir.
Thank you, Your Honor.
Ms. Holmes, you've got a sentencing on Cameron Gutierrez. Sentencing on Cameron Gutierrez. Good morning. Good morning. Are you Cameron Gutierrez?
Yes, ma'am.
And Mr. Gutierrez was previously in court and entered a plea of guilty to evading arrest or detention with the use of a vehicle in cause number 25 DCCR 0325. I've received that precedence report. Have you both had an opportunity to review it?
Yes, Your Honor.
Yes, sir.
Any additions or
None
corrections?
from the defense.
No for the state.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation at the end of the probation period, the case will be dismissed and you'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, which would make you a convicted felon, and sentenced to prison for anywhere in that punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Thank you. Mr. Kelly. I lost Mr. Kelly. Mr. Mitchell, you've got John Van Wright, 2 cases.
Yes, Judge.
Good morning.
Good morning, how are you doing?
Good, how are you?
Oh, I can't complain.
It's Monday. Nobody would listen if we complain anyway, right?
Go there for Fort Worth to be here though.
That's right. Good morning, sir. You are John Van Wright, and this is 24 DCCR 2485 and 15 23582. What is the announcement?
As far as the NTLP, it would be not true, Judge.
Okay.
Until you know.
I think we just prove up the MTRP first, Judge.
Okay, so let's do this then. Let me get that pulled up. We'll go through that entire motion and then we'll get an updated report and set it for sentencing. Mr. Van Wright, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. And will he waive the formal reading of the motion?
Yes, Judge.
Mr. Van Wright, in cause number 15-23582, I have a motion to revoke your community supervision. Shows that you were placed on probation July 28th of 2020 for the 3rd-degree felony offense of injury to a child, elderly, or disabled individual. And that was a 10-year term in prison, but it was probated for 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the offense of injury to a child, elderly, or disabled individual November 14th of 2024. And is that true or not true? All right, did you enter your plea of not true to count 1 freely and voluntarily? All right, then I'm going to...
And that brings us to the end of this courtroom hearing. What started with a serious probation violation ended with the judge offering one final opportunity, but under extremely strict conditions. The warning was clear: one more violation could mean that 10-year sentence becomes a reality. And then we saw another case where repeated DWI allegations pushed the court to focus heavily on public safety and strict bond conditions. These hearings show just how quickly a second chance can become a final chance in court. What do you think? Was the judge right to give probation another opportunity, or should the full sentence have been imposed? Let us know your thoughts in the comments. If you enjoyed this courtroom breakdown, make sure to like, subscribe, and turn on notifications for more real courtroom moments and legal analysis.